Welcome everyone. Good morning, good afternoon to all of you wherever you are. So welcome to the next set of conversations with Qapita. So today we talk about another, I think, very relevant topic. Also a very important topic for a lot of founders. And I feel, and Garima can add very soon, is doesn't get talked more enough. Fundraising is generally associated with pitch deck, storytelling, you know, and all that you see on television these days. But there's a lot that happens, beyond that as well. After say the term sheet is signed, and it definitely many a times it becomes a very long drawn process, takes weeks and months, right? So today we're going to talk about the compliance aspects involved, and we see this, that a lot of founders might inadvertently, commit a lot of mistakes during that journey that might show up later, with the regulator, or maybe as a perhaps a red flag in your next funding round. So these topics, it's better to kind of be aware of these topics around compliance, and we'll decode every aspect of that, and be prepared and obviously take professional help. So to decode this, I have Garima with me, Garima Mitra. Garima is the co-founder of Treelife and also a very close partner to Qapita. So welcome, Garima. How are you doing?
Thanks, Shrikant, and thanks for inviting me here. I think it's always great to have conversations with you and Capita, and I think looking forward to a great chat today around fundraising.
Wonderful, wonderful. And so maybe Garima, why don't we start with a short introduction about yourself and Tree Life, and what do you do? That'll be great.
Sure. So I'm Garima. I'm a lawyer by profession, and I am the co-founder at Treelife. Treelife is a consulting firm for legal, finance, and compliance needs of startups and investors. What we essentially do is take care of end-to-end business backend needs for startups and investors. So we've been in the industry for almost around 8.5 years now, and started when the startup ecosystem just started booming in India, and I think we've seen how the landscape has changed, and looking forward to better things in the startup ecosystem now. So essentially, we take care of everything right from incorporation to valuations to fundraising documentation like SHA, SSA, then ESOPs, of course, with Capita, and then the compliance related to fundraising.
Great, Garima. Thanks for that quick introduction. So let's now dive right into the topic. And thanks for everyone tuning in. The comment section is where you can ask all your questions. We can keep it as interactive as possible. I have a few questions lined up, and which Garima will answer, and then any other questions I can bring it up during the conversation or maybe towards the end. So that's the way we will kind of do it. We'll keep it crisp so that we'll try to have as much insight packed into this half an hour. So Garima, like we were discussing it, and when we were discussing about what should we really talk about, I think this was one of the topics that stood out. And you said we should definitely do a session on this, right? So maybe for a lot of maybe founders tuning in, can you describe the fundraise process? What does the founder typically go through, and how much time does it typically take? Maybe at high level you can talk about it, and then we'll zoom into each of the elements.
Sure, absolutely. So I think it's a misconception that once you've signed the term sheet, you're going to get the money and everything is going to be hunky dory, right? But it actually doesn't work like that. So it starts with a term sheet. The term sheet is only a letter of intent, and then moving forward from there, there are three parallel processes that generally happen. Like a due diligence is taken place, and then there is the compliance part of it, and then there is the legal documentation, that is the SHA, SSA. Now, all three of these have to be uh, binded together, and then that's when you actually receive your funds. And that process from the term sheet to the actual hitting on of funds can take anywhere between 3 to 5 weeks. and the idea is that all of these processes generally run parallelly, right? And the more efficiently that they run, and there are certain there are certain triggers that need to be taken care of. There are certain challenges that come up that need to be taken care of. There are certain maybe non-compliance that comes up that needs to be plugged. There's SHA and SSA negotiations that are being done. So it's a complete chaos. But ideally, the idea is to give method to the madness, right? And I think that's what you
Right.
can see in front of your screen, that there are like it's not just purely legal, or it's not just only compliance. It's legal, it's finance and compliance together, binding and coming together to get your money in the account.
Right. No, I think thanks for mentioning. Yeah, it's a long process, like you said. Sometimes it can get complex, and also multiple aspects associated with, right? I think you've nicely decoded three different kind of streams of lines of work, maybe. And there are obviously nuances associated with each of them. Maybe if I were to focus more on the compliance side for this discussion, where do they become relevant? Like you said, soon after term sheet, there are a bunch of things you need to do. So you want to decode it at a high level, and then we'll again go into each of them from there. Yeah.
Sure, absolutely. I think right in front of the screen also that we can actually see the journey for the entire fundraise. So once the signing of the term sheet is done, and there are certain legal documentations have been served, there's a parallel process of compliance, right? And that basically includes pre-funding compliance, and from the pre-funding compliance, then you get the fundraising. And after the fundraising also, there are certain compliance that steps that need to be followed to ensure that corporate governance in a company is uh, under the framework of the laws that we have, right? And after that only it's going to be completed. The transaction cannot complete without these corporate governance steps being taken care of. So what we'll do is we'll break it into a pre-funding compliance, then the money hits your
Mhm.
account, and then there is post-funding compliance that way.
Sure. And before we go into that, Garima, like at a very high level, what are the different? See, we keep hearing there's companies law, there is, there's taxation aspects, there is RBI, FEMA. So, what are the different, regulatory frameworks under which, these compliances kind of broadly fall under?
So broadly, there are three acts that you have to
Hmm.
comply with when you are raising funds, right? The first and
Right.
foremost being the Companies Act 2013. Then there
Hmm.
is your FEMA, that is the Foreign Exchange Management Act. Now, this comes becomes applicable only if you are raising funds from an entity or a person who's based abroad, right? Or who's
Hmm.
basically has a non-resident status. Otherwise, FEMA does not get triggered, right? Otherwise,
Right.
it is just Companies Act. And the third and foremost, the third main act that you have to comply with is the Income Tax Act, obviously. Now,
Right.
while we have an overarching jurisdiction of the Income Tax Act on every aspect of business, right? It's similarly for fundraising also. So,
Right.
ideally, in a typical, say, Series A round, or just a little bit pre-Series A rounds, if you have an institutional investor, then at that point of time, mostly they're going to be sending in money from their offshore entities, and that's basically going to trigger FEMA, right? So, which is why typically three broad frameworks: first the Companies Act, the FEMA, and then Income Tax Act. So all three of them have to basically complied with, and all actions within them have to talk to each other.
Got it. And that's a good starting point. I'm sure we can zoom into each of them now. So maybe the next question I would like to ask is, what are the specific compliances? You talked about FEMA, so maybe let's double click on that. So anything you want to talk about, what are the compliances involved when someone is receiving investments from outside India?
Sure. So I think what we'll do is we just take the various touch points on compliance, and then because
Hmm.
so FEMA generally comes into picture on the post funding compliance, right? And
Okay.
pre-funding is basically a little bit of just registrations under FEMA. So I'll take you through those, right?
Right.
Can you? I think can you go on the slide for
Yes.
secretarial
Yes.
compliances? Yeah, the
Yes. I
next
think
one.
this kind of broadly you covered the three
Yeah.
four pillars, right?
Yes.
Yeah. Got it.
Yes. Yes.
And
Yes.
yes, is this the slide? Yeah.
Yeah, yes, perfect. Okay, so ideally, the first 2 points, that is the increase in authorized share capital and the offer letter for private placement or rights issue, will go as a pre-funding compliance, right? So think about it in a way that when a company is raising funds, at that time it is going to distribute or offer its the securities that the company has. Now, to do that, the company actually needs to have space on its share capital to allocate that share capital to a third party coming in. Now, for that purposes, we have to increase the authorized share capital if there is no place on the share capital table for it, right? So that is why this increase in authorized share capital becomes an extremely important step, right? Now here what happens is there's an extraordinary general meeting that you have to take, and after that there are a couple of form filing actions that need to take. Now, earlier, before the new MCA, the Ministry of Corporate Affairs website version came in, this was a approval based form, right? A form SH7. This was an approval based form, and that would take like anywhere between 10 to 20 days to for the approval to come in. Now, which is why this was a very, very important touch point at compliance, that as soon as your term sheet is signed, you have your cap table finalized, then the SH7, or you have to start working on your authorized capital increase, right? Because then that sort of means that you have to file a form and the regulator has to approve it. Now, when the regulator has to approve it, there is a certain contingency that is involved which can work as bottleneck. So, which is why this was a very important compliance touch point before. Now, of course, it is taken on record very quickly. The MCA has changed this process a bit after the new website has come in. But of course, this action point is a very important point which needs to be taken care of before you are offering any shares or before the company actually is calling for money from the investors. So this is the first touch point. Then the next touch point comes in when you have to basically offer the securities, or rather, you have to basically now open the issuance or open the offer to raise money. This is of course, while parallelly there is the shareholders agreement and the share subscription agreement being signed on the legal side. On the corporate governance side, the company basically has to actually invite people to participate, right? Now, as a private limited company, what you do is you do a private placement offer. Now, you do a private placement offer or a rights issue. Now, rights issue is for your existing shareholders, whereas private placement is when there is a closed group of people that the company is invited to invest in, much like your fundraising transactions that happen. So for a private placement offer, you have to basically get a complete set of invitation on an offer that is ready, which basically talks about all your, it's like a mini prospectus of the private limited company, right? So that has
Right.
everything, right from your cap table to your business of the company to the financials. So it's a robust document, and it's basically called as the pass 4, right? And this is basically the offer letter that is given to the investors to invite them to invest in the company. Now, this pass 4 has to be basically offered or sent to your investors only after a form MGT 14 is filed. Now, this MGT 14 is filed as a form for the resolution that is passed in your extraordinary general meeting. So when there has to be a shareholders meeting which basically passes a resolution to offer securities to a select group of people, right? And that sort of triggers this entire fundraising process after your increase in authorized share capital. So then once a special resolution is passed, then you have to file the MGT 14. And once the MGT 14 is filed, you then send out the passport to your investors, inviting them and calling for money. Now, one of the major problems here, what happens is that there are a lot of smaller nitty gritties that come up in a private placement offer that needs to be taken care of, right? Now, and we've also recently seen that the ROC, Registrar of Companies, in all jurisdictions is penalizing non-compliance with this section or for corporate governance under private placement offers, right? And most of them, the orders that have been passed have been against certain startups itself, right? And the penalty is pretty
Right.
high under this section. It's almost 2 crores or the investment amount, whichever is higher. So smaller things that need to be taken care of in while we are doing this private placement offer is that because generally and typically all investors take a CCPS instrument, private placement is
Right.
the go-to mechanism to use for the share issuance, right? And I think uh, the important touch points here is that A, you need a separate bank account where the money is going to come in to your company. So this has to be a completely separate bank account in a scheduled bank. Then uh, second is that this MGT 14 filing needs to be done before you send out the pass 4 or before you call for the money, right? A lot of people miss that this MGT 14 has to be filed and only then can you actually call for the money. And after you've called for the money and the money actually hits your account, you can't immediately use that money. You have to wait till the time the next step, that is the post investment compliance, happens to actually start using the money, right? And
Okay.
the fourth and the last point in this is that you need a valuation report, right, which is compulsory. And the valuation report should not be uh, earlier than 30 days of the issuance that you're doing. So, say for example, if I wanted to open up my invitation or issue my shares on 27th July, I cannot have a valuation report that is of yesterday. It needs to be at least of, 27th June 2023. So that's the last day for it. So I think that's also something that a lot of people miss out because that's not in the that's in the pass 4 format and not in the act itself, but it's still
Right.
taken into consideration, right?
And here the
So
valuation
yeah,
report is the registered valuer.
registered
Is
valuer
that
report. Yes, yes, yes,
okay?
the registered valuer
And
report.
what's there's also the merchant banker, right? So that's more for other acts, right? So you want to
So,
elaborate on that?
sure. So basically, the main act for compliance of private limited companies when we're talking about fundraising in startups is the Companies Act, right? So,
Right.
registered valuer is the first report that you will require if you're doing a private placement offer. In
Got
case
it.
you're doing a FEMA transaction, so in case you're getting an investor from outside India, you will require either a chartered accountant valuation report or a merchant banker report, either one of them, right? And if you are basically um, if you are issuing these shares to an investor in India, right? there are certain fund compliances, and if say institutional investor is involved, right, then they require basically a merchant banker report under the Income Tax Act.
Got it.
Yeah.
Got it.
So ideally, for in a given transaction, there are two reports minimum that you require. One is a registered valuer report and a merchant banker report. So the merchant banker report that you have will basically serve for under the Income Tax Act also, and under the for the RBI purposes also
RBI
under
part.
FEMA.
So
Yes.
just to, I think we have unpacked a lot of things. So let's just summarize until now. So let's
Sure.
say somebody is raising capital. So it's all this starts after the term sheet and the SSA also, right? SSA, SHA
Correct.
is where
Yes.
the first thing is checking the authorized capital. Here, just one question, Garima. So typically, like you said, for investors, companies issue CCPS, right, and not equity
Correct.
shares. So
Yeah.
does that mean that's a different kind of pool of authorized capital, or that's within the same? Um,
So the
uh,
preference shares are a different pool of capital. So
Whole.
you
Correct. Correct.
segregate your capital from equity. It is not the
Okay.
same pool of capital.
So it's more like if anyone is raising from institutional, it's more likely you will have to increase your authorized capital, is what
Yes,
you
yes,
observe,
absolutely.
like basically.
Because when you
Okay.
are incorporating a company, you generally don't put preference capital in it, right?
Exactly.
It's
Yeah.
yeah. So and I mean, not even just institutional investors, even like angels nowadays have started preferring a preference share only. So
CCPS.
ideally, any
For because
smaller
that's
number.
where correct. The investor rights, getting preferences, liquidation,
Yes,
and those will be allocated to that class of shares, basically.
correct.
And then, so once that is done, that's basically a very hygiene, because only if you have authorized capital is when you can issue those securities. And then you get into the actual process. The first you are saying is the most important is even before taking in money is, calling a general meeting and filing the MGT 14 and the PAS 4, right,
Correct.
which is for
Yes.
the offer letter basically for the participating investors, right?
Right.
So this is basically all this is kind of done and already kind of done in the shareholder agreement and share subscription agreement, but this is a formal way of communicating this to the ROC, the MCA, right? Is that the way we look at it?
Absolutely. Absolutely.
Right.
So this is basically a corporate governance that you could call. So these are
Correct.
certain compliance steps that the company has to undertake.
Undertake. Okay. And
Yes.
then is the actual allotment of security. So that is path three. So this follows the transfer of capital.
Yes. So for
Yes.
the allotment of securities, you actually need to have the money in your account.
Right.
So
Got it.
once the money hits your account, if it's a private placement offer that we are doing, then you cannot use that money till the time this return of allotment is actually filed. Now that is called, and that is basically done in form PAS 3.
Got it. Got it. This
Yeah.
is really helpful. And then and following that will be the issuance of shares also, which is the formal like share certificates, which is more something that the companies issue to the investors, right?
Correct.
That follows
Yes.
the path. Okay.
Yes. So
Got
after
it.
you have allotted the securities, then you have to basically issue share certificates, which is the actual title document of the shares, right? So that is
Got it.
basically proof that you have bought shares in my company. Now, and
Got it.
that also, these share certificates have to be stamped adequately. So they're stamped
Right.
under each of the state acts. So wherever the registered office is of the company, you stamp your share certificates accordingly. So this is one of the touch points which sometimes gets missed, right? Issuance
So
of the share securities, share
yeah.
certificates, and the stamp duty on it.
So can we just pause on this part because again this
Of course.
also has a lot of confusion, right? Like there are investors from all kinds of there can be foreign investors, investors can be from any part of India also, let's say, and there's company, right? So where does the how do we decide the jurisdiction? Is it the jurisdiction of the where the shareholder agreement is signed in some sense, and how does this operate in like when things are also happening virtually? Yeah,
Got it. So you have to basically look at for the stamp duty jurisdiction. It is generally in the uh, the jurisdiction of the registered office of the company. So if my company's registered address is in Mumbai, then I will use the Maharashtra Stamp Act. If it is in
Okay,
Bangalore, I will use the Karnataka Stamp Act. So it depends on where the company's registered office is located.
got it. You want
Yeah.
to touch upon, I know this again is a slightly verbose slide, but any
Yeah.
quick, you want to touch upon this on the stamp duty part?
Sure,
Yeah.
of course. So I think so. Stamp duty is one of the jargons that a lot of lawyers, a lot of company secretaries use, right? And this actually becomes applicable on all the agreements that you do, right? So the SHA requires a stamp duty, the SSA requires the stamp duty, and your share certificates also require stamp duty, right? So if there is any transfer of shares also happening, that also gets stamp duty gets triggered there as well, right? But the idea is that for a fundraising transaction, on agreements you're paying certain stamp duty, and you're also paying stamp duty on the share certificates that you're allotting to the investors. And this depends, and
Got
this
it.
is state wise. So wherever the SHA or the SSA basically is getting signed, that is the jurisdiction for the stamp duty. And for your share certificates, the jurisdiction is where your registered address is.
Got it. Got it. And so there are different states will have different, I think, percentages and
Yes.
all of that. Again, you
Yes.
would need to take professional help in this and get these things done, right? Got it,
Absolutely.
Karima.
Yeah.
I think yeah, we took a detour, but I think let's switch back to the original flow that
Yeah.
we were discussing. So yes, we need to take you mentioned the three places where we need to take the stamp duty. And then
Yes.
you want to continue this? Like,
Of
I mean, this
course.
is also is something I see in my experience. Not a lot of founders that, once the SHA and everything is signed, they also need to change the articles. So, you want to touch upon that?
Correct. Yeah. So I think this is one important step that a lot of people miss out on, right? That once your SHA signed, once the money is hit, you've given the share certificates. Uh, the AOA amendment is something sort of overlooked sometimes, right, or missed out.
Correct.
And this is very very important because the rights and obligations that you have under the SHA get duplicated in the AOA. Now, which is
Mm-hmm.
why you change this AOA after a fundraising round, because the AOA is basically the charter document of your company. It's the Bible or the process document for your company, right? So, any question that you have about corporate governance, AOA is the document that you open. And similarly, in a fundraising round, your SHA is your Bible. If there's a problem, you open up the SHA and see what is what, right? And what has been agreed upon. And while the SHA gives out contractual rights, when this SHA is actually included in your articles of association, is when it actually becomes statutorily applicable on all the shareholders. So, which is why it's a very important step, more from the investor side, right? And that's why they're very, very insistent that the AOA is basically restated or changed after as soon as they become shareholders of the company.
Got it. No, that's a very important point. So I think founders will make note. I see there are a bunch of questions.
Sure.
I can cover some of them. I think one there's a question on whether the share certificates need to be stamped by CA and is it absolutely necessary? Any quick reaction to that, Garima?
It's absolutely necessary, and I mean, a professional can help you to procure the stamp duty, but generally, this is offered by the government. The stamp duty is the fees that you pay to the government, right? So there are
Right.
certain, yeah, vendors allocated by the government who do it,
Okay.
and it
And
is absolutely
stamping by the
necessary.
CA part, I mean, is that something you see?
So a CA is a professional who can help you to get procure that
Okay.
stamp
Okay.
duty from the government vendors, but he is not eligible to do anything or give you stamp
Okay. He's
duty.
not signing or stamping. Okay. Got it.
No.
Got it. Okay, and perfect. And then there are a few questions we can take there's also one question by Harsha is, if the investors, if the VC is in India, maybe it's an AIF, and they have LPs from other countries, does the FEMA come under is applicable? Maybe here two things, right? Whether when the investment to the company, maybe that might be the question of relevance in this discussion, but you can answer it broadly as well.
So, from the company's perspective, basically, you have to see that from where the money is coming in, right? If the entity
Okay,
is putting the money from an Indian entity, right? Even though it's a fund, if it's a SEBI registered fund and is located in India, and if that money is in India and it's coming to the company, then it is an Indian investment. However, there are certain offshore entities from where money comes in from for some of the funds, right? And that is basically categorized as FDI. Now, there is
right.
also another concept where there are certain investors who have basically are doing an investment which is a downstream investment. So they may have foreign money, right? And however, the that money has already come has been exchanged and come to India, and the INR investment is happening. At that point of time, there is a different compliance, but that compliance is on the investor, not on the company.
Got it. Got it. So maybe in this specific case, if the fund is based out of India, then I don't think there'll be
Yes.
FEMA for the investment into the company. But of course, the fund will have to comply for taking money
Yes.
from the foreign LP into the fund itself. Right.
Correct, correct,
Got
correct.
it.
Yeah.
I think Santosh is asking, can franking be done? Maybe this is applicable to the stamp
Yeah,
paper,
franking
right?
and
Is
stamp
there
duty
a,
is one
yeah.
and the same thing. Some places you can
Okay.
get it franked, like I mean,
Okay.
in Mumbai, sometimes you can get franking done as well. There's no problem.
Right. Right. Abhilash is asking typical timeline from getting the term sheet to money in the bank. I think that's $1 million question, literally.
I would like to
But yeah,
hope, on a best case scenario, anywhere between 3 to 5 weeks is what we generally
okay,
assume.
that's a best case. Yeah, yeah.
Yes.
Things fall into place because term sheet after term sheet, there's also due diligence, right? Now that can
Correct.
take any.
Yes.
I mean, depending on what the investor wants, it can take any number of time. But then typically
Absolutely.
after the due diligence is once the SSA SHA is signed is where all that we discussed kind of comes into relevance. So this you would say will still take 2 to 3 weeks
Not really, actually.
if
Once
all goes
you
right.
have,
Yeah. Hmm.
no, once you've finalized
Mhm.
on your SSA, SHA due diligence is done, then it's not that big a time gap. So that after that,
Got it.
everything can be completed within a week's time.
Okay, perfect. That's good to know.
Yeah.
That's
So
good to
just
know
the
for all the founders
compliance
tuning in.
steps.
Yeah,
Yeah.
right. So there are a few questions which are not super relevant. I'll take them towards the end, but I think we should, in the
Sure.
interest of the flow, we should continue. I think Abhilash asked what's MIS. I think that's just Management Information System, right? But I don't think that's relevant in all that we're discussing here. That typically MIS you give to your investors, right? So Pankaj asks when the valuation report can be taken for private placement and how old can the valuation report be? I think you touched upon it. You want to reiterate this point?
Sure. So, I mean, the earliest that you can take the earliest that you can take that valuation report would be 30 days. So there has to be a minimum gap of 30 days between the valuation date, like the relevant date of the valuation, and the date of the issuance.
Okay,
Yeah,
got
so
it. I
minimum
hope that
30 days
answers.
gap
30
needs to
days.
be there. And if you're also doing a FEMA transaction, typically it needs to be not older than 3 months. So not older than 3 months, but not earlier than 1 month. So that's the sweet spot for your valuation date.
Okay, things are getting complex. Okay, maybe we can continue on we're talking
Sure.
of FEMA, right? So the RBI side
Yeah.
also, let's close this slide and we can go to the next topic. Yeah.
Correct. So I think, yeah, so RBI reporting, like we said, that this is generally coming in place where there is a foreign investor, and the foreign investor basically will invest, and at that point of time, the money gets exchanged and then hits your bank account in INR. Now, for this purposes, now it's completely online. Earlier, it used to be a physical filing. So there are Pre-funding, generally you get an entity master and a business user registration on this RBI firms portal, and through that you file a form FCGPR, and this has to be done within 30 days of the date of allotment. So once the money hits, you've allotted the securities, from there you need to get this RBI reporting done within 30 days, the FCGPR filing. And this
Got it.
basically FCGPR filing requires an FIRC and KYC from your bank. Now, your bank is basically the authorized dealer or the ED bank who has changed your foreign currency into INR. And that change is basically reflected through the the FIRC, that is the foreign remittance certificate, and KYC that your bank gives you. So, and also another sort of a challenge that a lot of times that is faced in this is that, when an investor is sending money from abroad, right,
Mhm.
they generally basically have to put in a purpose code, which is basically for the investment in India, investment in securities in India. Now, the purpose code actually should be correct. So, idea is that when you're calling for money, like a good thing to do would be to just sort of touch upon uh, with your bankers to understand, okay, what instructions should I give my investor to get in the investment money, and that sort of sorts things out rather than the money hitting your account under a wrong purpose code and all of that.
Got it. This is helpful. Great. I think there are a couple more questions, but I think one topic we didn't broach or discuss, Garima, is different instruments. I think somewhere I think we were
Sure.
we assumed that these are all shares or share-based
CCPS,
instruments,
yeah,
CCPS. So should we touch upon that part, like
of
how
course,
this
yeah,
plays out? Because a lot of early stage funding also is through convertible forms of instruments, right? And again,
correct.
we loosely talk about convertible as CCD, SAFE. I mean, CC plus also is some form convertible in some sense. There's convertible note, right? And there are other forms of instruments in other jurisdictions also. So if you can bring some context, one, what are these instruments that are typically seen in Indian context? And then we can go into the nuances associated with them.
Sure. So I think the most popular distinction is between an equity share and a CCPS, that is compulsorily convertible preference share. Now, equity shares is the common stock of the company, and these are the shares that even the founders hold. Now, while we were talking about all of these compliance steps that needed to be done, we basically checked on CCPS or CCD, right? And these are the convertible securities that a company can issue. Now, CCPS are preference shares and compulsorily convertible preference shares, like I said, and are the ones that are popularly used for valued rounds, right? Whereas a CCD is generally used for a bridge round, or where you're sort of doing a complete convertible, where the valuation or the conversion of your securities is dependent on your next round of funding, that ways. So I think that's the major distinction between a CCPS and a CCD. Both are issued through private placement offers, right? And the process remains typically similar when you go to a compliance point of view. Just that for CCD, you don't require to increase your capital because these are your debentures. Now,
Okay,
another
interesting.
point, yeah, another point is actually the convertible note, which has become popular. Now, when you don't know the valuation of your company and you want to completely peg it to the next round of funding, and want probably a hybrid instrument, which is a debt plus equity, then convertible note is a very popular choice, which has the least compliance of all, right? It doesn't require any private placement offer. It just requires a simple shareholders resolution, and you're good to go. But the main thing to basically keep in mind when you're raising money through a convertible note is that the minimum investment amount has to be 25 lakhs per investor, like per tranche has to be 25 lakhs, right? And this basically can have a coupon rate or anything and can convert after whatever time that you provide. And from here, from this convertible note, basically, it is on the investor to sort of choose whether they want to convert it or they want to take the money back, since it's a debt instrument. And the company has to be a registered startup to raise money through a convertible note. So when I say a registered startup, it is a DPIIT registered entity as a startup. Only then can it actually raise money through a convertible note. And of course, this is a quasi equivalent of SAFE in the US, right?
Right.
But yeah, so but still, it has certain caveats that it needs to have a tranche of 25 lakhs in from a single investor, and you need to be a startup to raise funds through a convertible note.
Got it. No, this is extremely helpful. So what you're also saying is when people say they're raising money from SAFE, and we also hear iSafe in India, but they're not really different instruments in India, but the instruments are basically one of these four, is what we have typically seen. Is that
Yes,
correct?
absolutely,
Okay.
absolutely. So, I mean, if you also see iSafe, the iSafe is typically just a CCPS, not anything else,
Okay.
but a compulsorily convertible preference share named as an iSafe. That's all.
Got it. And convertible note, when you say the process is simpler, it's because there's no private placement involved. There is, like you said, a shareholder meeting, so there might still be some filing, I guess, for the meeting, but there's nothing from a issuance of security point of view. It's more
Correct,
a
correct.
note that is being issued. Okay.
Is more like a note, right? So it's just a
Yeah.
shareholders meeting is conducted, you file a form MGT 14 and you're good to go. You
14.
don't require a valuation report also in this. So it's fairly
Okay.
simple. Yes, and
So
quick.
the slide that we earlier saw for equity share, CCPS, CCD, all the most of the process is applicable for all the three, right? The
Yes,
process that
yes.
we okay. And convertible note is a slight exception, but again there
Correct.
is a constraint of the 25 lakhs minimum
Yes,
investment as well,
absolutely.
which also like especially if you are in if in the angels are involved, maybe not all of them would be committing 25 lakhs. So in
Yeah,
that case, it might not work.
correct, correct. Absolutely.
Okay, wonderful. And a couple of questions on the validity of valuation report, Karima. You want to comment on that? I think you did touch upon this briefly, but any validity wise as well?
So validity wise, basically, this is that 3 months is the validity of the report generally, because now RBI has come up with these rules that any kind of issuance or transfer of shares, the valuation report cannot be dated older than 3 months. So which is why everyone is now. The industry practice has become that 3 months is the ideal validity of a valuation report.
Got it. Got it. Great. I think we've covered a lot of the things we had in mind. There are a couple more questions. Maybe I'll take the one. I think Santosh is asking a very specific question of his FCGPR filing getting rejected. So you want to take that up? Like RBI portal has rejected their filing related to the valuation report format issue, and 30 days timeline has crossed. So will there be a penalty? Is there something you want to
Yes.
answer here, or we can connect offline as well? Yeah.
So we can obviously connect offline with
Hmm.
him, but I mean, just to answer that, yes, there will be a penalty. It's called as late submission fees. So while RBI does understand that there may be delays, they once they approve the FCGPR, they give you a no. They in their remarks, they basically calculate your late submission fees based on your investment amount and give you an amount that needs to be paid to RBI for delay in FCGPR filing.
Perfect. I hope Santosh that answers. We can obviously correct offline and connect you to Garima and team as well. I think one question earlier was asked with regard to, I mean, this is not related to fundraise or primary, but what key pointers to look at during an exit of a startup? Any compliances related to exit of a startup? Again, that's not really the scope of today's discussion, but Garima, you want to touch upon that and at a high level answer that?
Sure. Sure, I think basically for at the time of an exit, generally it's a secondary that we are looking at, And for secondary transfers, generally, so for secondary transactions, what we generally look at is a transfer of shares, and that transfer of shares is effected by a form called SH4, which is signed between the transferor and the transferee. So both the people, one person who's transferring and the other who's basically getting the shares. And that SH4 also you need to pay stamp duty on, right? And then of course the share certificates have to be handed over. So if basically you are someone who's taking the exit, then upon getting the consideration, you have to hand over your share certificates to the party who is buying shares from you. There has to be a valuation report on this transaction. Again,
Hmm.
it has to be a merchant banker report. You don't need an RV
Right.
report here. You need depending on the instrument that you're transferring, right? You will need either a CA report or a merchant banker report under the Income Tax Act.
Hmm. That's a good point as well. Okay, because
Yeah.
there are tax implications
Yes.
to the person receiving the money. Yeah.
Correct. And there is
Got it.
also like for someone, for an investor probably, or someone who's actually buying the shares, we've also seen that they insist on a residency certificate under the Income Tax Act that is required. So that residency certificate is required under the Income Tax Act, where um, uh, basically a CA will check if you've paid all your income taxes, and where your residency actually is. If you're saying that that you're an Indian resident, then you get a residency certificate. So that's also something. It's not compulsory, but that's something that we've seen, getting used in an exit.
Got it. Again, very helpful. Maybe we might require another session on that. Just one more question from another audience here. Like, if the founder needs to transfer shares more than 70% to his or her co-founder, can that be done? Maybe it's more. First question is about more of how the process, and even after the amendment of AOA, maybe the fundraise has happened, and yeah, and there's a internal transfer that needs to happen. What are the steps to be taken and what are the costs or risks? Anything you want to touch upon on
So
this?
I think this is a very very specific question, right? Because if the
Right,
AOA is changed, then we have to actually go and see what the lock-in provisions are, and there may be certain ROFR obligations that the founder has before transferring his or her shares to
right.
someone. So I think it's a very, very specific question that we'll have to answer offline only once we actually review the document. Otherwise, but to answer it simply, you can do it. Not that you can't do it, but the steps is something that we'll not be able to comment on without seeing the document if the AOA is
Correct.
changed.
And then if there's a valuation involved, then obviously there might be taxation involved. I mean, in transferring.
Yes, so
So
the
yeah, a
transfer of
lot of
shares,
things.
yeah, the process remains the same, right? But the
Right.
other obligations are something that we'll have to check on.
Correct, correct. No, that's useful. So maybe you can reach out to us, and we can put you in touch, or you can reach out to Garima as well. I think we've kind of come to the end of all the questions that were asked. Again, if there are any last set of questions, let's take them. I think we'll extend this by another 5 minutes. Garima, maybe if I were to ask you, right, and you've done hundreds of transactions, I would say. So, what are the maybe top five mistakes you've seen as a takeaway, right? And we can take it step by step also, and so that it can be a good takeaway for everyone tuning in. Yeah.
Sure. So I think top five is, of course, the first would be to not involve a compliance professional soon enough. I think
Okay.
ideally what happens is that everything else is falling into place, but then compliance tends to become a bottleneck if you don't have someone who's driving it right since the beginning, right? And that may delay the process. So ideally, I think the first mistake that is done is that compliance professionals are not involved fast enough or quick enough. So I think that's one mistake that I've seen. Then second mistake that I've seen is at the time of incorporation, um, uh, a lot of founders miss out on paying stamp duty on share certificates, and then heavy penalties have to be paid on that. Similarly, at the time
Hmm.
of fundraising also, this the process generally is not followed in a way that, okay, because you're looking to get that fundraising, right? You just take in the money, random amounts in your bank account, and it's just lying there. You've used it already, and then no compliance steps have been taken care of. So I think that's one thing that founders should avoid, right? The idea is to sort of go in a structured manner there, right? Then third is, of course, when you're talking about a FEMA transaction, like I
Hmm.
pointed out, that there are times where the purpose code is wrong for the money that comes in, right? So you should always be in touch with your banker, saying that, okay, I'm going to get a new investment from abroad, and what should the instructions to the foreign bank be when they're sending out money, because otherwise sometimes you're unable to trace the where the foreign exchange was converted into INR, and then it all creates a lot of mess which delays this FCGPR and all of that process, and in the end you then end up having to run around a lot, and then do a lot of these pay a lot of these late submission fees for FCGPR. And I think another point that we probably didn't touch upon, we touched upon the valuation report, right? And that we basically require a registered valuer report and a CA or a merchant banker report, right? But a merchant banker report may not be required if a fund is not insisting, if you have an angel tax exemption, right? So when an angel tax exemption is there, at that point of time, the startup need not get the merchant banker report if the investor is comfortable. Now, when that angel tax exemption is something that you have, what is actually a major compliance for the angel tax exemption to be in place is that you can't invest in certain places, the investment that you get, right? Like in, say, mutual funds or in shares and securities of other companies, jewelry, real estate, or some things like that. Like there's a declaration that you file. So ideally, that has to be kept in mind, that you've signed a declaration. If you have that angel tax exemption, you should not go ahead and use the investment amount for the things that are mentioned in that declaration. Otherwise, you tend to leave your exemption that you've applied for. And that also includes sometimes mutual funds or other companies' securities. So ideally, that's something that you should be mindful of.
Got it. This is extremely helpful. Any other points you want to add, Garima? Like where founders can exercise some caution. I think the first point is more important. Like I think founders should take professional help. They might not be aware of a lot of these nuances, and also interfacing with the MCA, ROC through the portals. Finding a lot of those things. It would definitely require professional help. But any other point you want to add? And I'll also request the audience if there are any last minute questions, we can take one or two more. But yes, if maybe Garima, over to you. Any last comments you want to make before we close?
I think we've covered quite a bit in the entire
Yes,
hour or so, and
yes.
I think that uh, the only last takeaway that I'd like to give these people who have tuned in is that, if you feel that compliance is expensive, it's a very very common saying that if you feel compliance is expensive, you should actually go and try non-compliance. So, I would highly recommend that, at least get some help, be aware that there are certain things that need to be done so that you're in compliance with the law. Because if you are not, the enforcement has become very, very rigorous now. It's also
Yeah.
penalties are being levied. So, ideally, because the startup ecosystem now has matured enough to understand that these are certain steps that need to be taken, right? And if
Yes.
not, then you lose out on money, which I think no
Yes.
business wants to do.
Yes, I think that's well said, Garima. I think we are seeing this as well. I think lot of reports of how the ROCs of various cities are becoming more active, in levying these penalties, kind of a thing. So yes, as Garima mentioned, yes, don't try non-compliance. I think it has a large cost associated with it, and hence taking professional help is extremely important. And yes, you can also try systems like Qapita, which helps you, have a framework where a lot of these things can be managed effectively. Of course, you still have to deal with the stakeholders like Garima and other agencies and things like that. So Garima, wonderful. I think there are no more questions. I think yes, I learned a lot actually in this 55 minutes. I'm sure our audience did too. I see some of those comments coming in. If you want to reach out to any one of us, you can obviously reach out to us on LinkedIn through the live itself. You can reach out to Qapita website or Treelife website and find a way to, reach out to us. You can fill the form or you can write an email to either of us, right? So with that, Garima, it was lovely having you. I think maybe this is the first of the many topics we would cover over a period of time. But thanks for actually patiently doing this. This was quite comprehensive in my opinion, because I've heard bits and pieces, but never really stitched all of this together. So I think thanks for patiently doing that and making it quite useful for me. I hope this was useful for the people tuning in as well. So with that, thank you very much. Anything else you want to add before we
No,
hang up?
thanks, Shrikant, and thanks for being kind enough. We tried to include a lot of things in 55 minutes. Let's hope
Yes,
everyone likes
yes.
it.
I hope
Yes.
people are able to
Yeah,
digest it. I will, of course, come up with more like snippets and maybe
of
some
course.
articles around this, and we will take the conversations ahead, as we say. So thanks again for the next edition of Conversations of Ed Capita. Today will obviously come more and more. Any suggestions you have on topics you wish we should cover, do again put it on the chat. We'll definitely pick it up and incorporate into the scheduling. Again, thank you, Garima and Jitesh and the whole Tree Life team. You've been a very good and kind partner to us as well. I will continue this conversations further.
Thanks,
Thank you.
Shrikant. It's a pleasure.
Thank
Thanks.
you.
Bye.
Thanks. Bye. Bye. Bye, everyone. Thank you.